Yes. Mr. Snowden, Mr. Platt, before we launch into it, a couple of things. Firstly, we've read the papers, some of the authorities, but not all. We think we have a pretty good appreciation of the issues, but there may be some things on which we'll need your help. We still remain of the view that the original one-day estimate was more accurate than the 2 days that have been identified. So whilst we may go into tomorrow, certainly if we do, we expect to have finished by lunch, if not well before. But we understand that we may go into tomorrow, but that's the warning. And if we do, we'll start at 10 tomorrow. All right? But other than that, far away. Have you agreed between you roughly how long you will be?
My Lord, we haven't. I expect, I'll explain in a moment why we're sat in this slightly unusual way and seek the court's indulgence for that, but I expect I'll be no more than an hour max, and if my Lord and my Lady have read the papers in detail, I may be even less than that. I'm going to open and deal with a couple of the grounds of appeal, and then my learned junior, Mr. Swoboda, who will take silk next month, and who conducted the trial below, and who has far greater working knowledge and still recollection even than I do at this stage of the issues in the case, is going to deal with some of the grounds of appeal himself. We're sharing the advocacy in that way. I'd asked Mr. Platt, and he has no objection whatsoever to Mr. Swoboda sitting beside me in those circumstances, and if the court is content that we do that, that's certainly our preference if the advocacy is being shared.
Are you dividing up specific grounds of appeal between yourselves?
We are, yes, my lady, yes.
And which ones are you taking?
I'm dealing 5 and 1 in that order. Let me begin then rather more formally. My lords and my lady, may it please you, I appear with Mr. Swoboda and Miss Waller, who is hidden behind me, for the claimant appellant. Mr. Swoboda appeared in the trial below in the High Court. For the defendant respondent, we have Mr. Platt, King's Counsel, leading Mr. Williams. This is an appeal, as my lords and lady know, from His Honour Judge Simon, sitting as a Deputy High Court Judge, a decision of December of 2023, dismissing a mesothelioma claim at the liability stage on the basis of causation not having been made out. He then declined to go on and give any quantum judgment in those circumstances. And we appear before you pursuant to permission to appeal granted on all grounds by my lady, Lady Justice Nicola Davies. That permission to appeal is at tab 8 of the core bundle. If I may be excused, some housekeeping matters first. I've mentioned my learned friend, Mr. Swoboda, who takes silk next month, sitting on the front row beside me, and dividing the advocacy between us. My lords and my lady, I will be dealing with grounds 5 and 1, and deferring to him in respect of grounds 2, 3, and 4. My lords and lady will immediately appreciate, therefore, that I am dealing with the issue of adverse inferences to be drawn from the fact that no air sampling was carried out by the defendants in these garage premises. And I will be dealing with the judge's, the manner in which the judge treated the expert evidence of Professor Norrie, which led him to conclude that he could go down a route which took account of extrapolations from a technical paper from Hodgson and Darnton, published in 2000. And I will deal with those two aspects of where we say the judge went wrong. Mr. Swoboda will then deal with grounds 2, 3, and 4, in essence, dealing with the issues between method 1 and method 2. What was the best methodology to assess the counterfactual risk? The legal arguments which make method 2 unsustainable, we said below.
You're speaking incredibly fast.
I'm so sorry. Forgive me, my lady, overexcitement.
Yes.
Well, obviously we share that.
And on every occasion. I am sorry. Forgive me. My learned friend, Mr. Swoboda, will deal with grounds 2, 3, and 4, drawing together our arguments on method 1 and method 2, why the judge was wrong to reject method 1, and even more wrong, we say, if I may put it that way, to adopt method 2. He will also deal with the respondent's new case articulated in their respondent's notice that there is in fact a method 3.
Can I just ask, this is curiosity, the phrases method 1 and method 2, have they arisen from this case?
Yes. Yes, they're not as far as, checking to my left, but they are not as far as I am aware in use anywhere else. Method 2 was articulated, we believe, for the first time in this case. And we simply called them method 1 and 2 because that's what the advocates below used to distinguish them in the judge's mind. I won't, given the indication from my Lord Justice Coulson that the court has read the papers and is on top of the issues, I won't unpack those different grounds in any other way, but will simply delve straight into mine in a moment, if I may. Prior to that, a couple of matters of housekeeping, if I may. The court should have, of course, a core bundle with the judgment below in it at tab 11, supplementary bundle of skeletons, closing arguments, extracts from the expert reports and joint statements, and some excerpts from the transcripts of evidence. The court should have 2 bundles of authorities, and if I stumble over referring the court to any, I hope you'll forgive me, I've had mine reduced to 1 on double-sided, so I'm afraid I may not necessarily direct the court to bundle 1 or 2 of the authorities, but if we can navigate by tab, I would be very grateful, and no doubt I will learn where the break point comes in the course of... The court will be aware that the defendant sought to introduce a full additional bundle of supplementary material.
Over 800 pages.
Indeed, which my Lady Justice Nicola Davies and Lord Justice Bean, I believe, considered and rejected. Yesterday, however, following up my lady's indication that a more focused application could perhaps be made, a more focused application was made to put in yet further extracts from the Hodgson and Darnton paper, the 2000 paper, which is at the centre of one of the papers at the centre of this case. And we don't oppose that going before the court. We don't know quite what will be made of it, so we wait to hear from the defendants, respondents, what they make of it, and we'll respond to that in due course. We believe there's also a further authority that my then friend Mr. Platking's counsel identified yesterday. He wants to refer the court to short extracts from the case of Durham, BAI runoff in the QB division in 2008. And my lady, I believe extracts from that have been placed before the court. Again, we have no, subject to the court's view, of course, we have no fundamental objection to very short extracts being put before the court. We think we can see what the respondents want to do with those, but again, we'll wait to hear and we'll respond to it when they do. And my lady should also, I hope, forgive me, my lord and my lady, should also have had put before you one correction to the authorities bundle, which is the extract from Ipsen on evidence. I hope that has reached your bench. With apologies again, due to the number of authorities, the extract from Lawtel, Westlaw, whichever it is now, had the penultimate edition rather than the current edition. So we've placed the current edition. So
this is simply the current edition.
This is the current edition.
The one in the bundle, which is the one before.
Previous.
Yeah,
precisely. The relevant paragraph hasn't changed. We simply put it before your lordships in case you wish to read the paragraphs before or after, out of curiosity to see what the editors say. But the relevant paragraph that's relied on hasn't changed.
Mr. Snowden, would we be right in thinking that Mr. Johnston's in court today?
Forgive me, yes, I should have done a further introduction. That is entirely my mistake. We don't have Mr. Johnstone, the claimant. He is unwell today. He wanted to be here. He hopes to be here tomorrow. We have Ian Johnstone, who is Elaine, the deceased's son, and the claimant's son. Sorry, forgive me. Thank you very much indeed for noticing, and forgive me for not mentioning that. Moving from housekeeping, if my lord and lady will forgive me a tiny bit of indulgence, simply to sketch out the background on our own terms before diving to the grounds. This, of course, is an appeal against His Honour Judge Simon sitting in the High Court on the trial of on the issue of causation following the trial of a mesothelioma claim. The court will have seen that the learned judge below heard evidence for 1 week in April 2023. He then received oral submissions in June 2023, but it was a full 6 months later that the judgment was handed down, not until December 2023. A chronology of that, should the court want to look at it, is at tab 6 of the core bundle. I won't take you to it now, but the court will see that various emails had to pass between counsel and the learned judge with, again, no particular criticism, save for the observation that considerable time had passed before the written judgment was produced, that you will see counsel chasing gently and the judge offering a date and then a further date and a further date. But we all know the busyness of professionals in these circumstances. But that's the factual matrix for how the judgment came to appear so long after the hearing. My lords and lady will already have picked up that this appeal is of importance, as it is the first time that an appeal court will consider the methodology for assessing material increase in risk in mesothelioma claims, which is a point of wide application. In our skeleton, we've identified for you that there are between 700 and 1,200 mesothelioma claims issued on an annual basis at the moment. So it's a very substantial area of litigation. And inevitably, as the court may know or may appreciate, the nature of those claims is changing. Historically, 20, 30 years ago, they concerned those who had had heavy and intensive exposure to asbestos in the course of their employment. Joiners, laggers, shipbuilders, construction workers. Now, the cases are far more what we describe as low dose, and therefore the area of controversy over how one can assess a material increase in risk when the dose itself is relatively low is more pertinent. I don't propose at this stage saying any more to the court about the substantive development of law that has brought us to the present position in respect of causation in mesothelioma claims. And I am taking it as read that the court knows in breadth or in detail the progression through Fairchild in the House of Lords in 2003, Barker in the House of Lords in 2006, followed by the Compensation Act of 2006, and then Sienkiewicz in the Supreme Court in 2011. And put extremely simply, and therefore I'll do it briefly for it may not be needed at all, we've ended up with what we say is the law achieving the right result within the limits of medical science, when any given individual may have many, many asbestos fibres in their lungs. No one can currently establish the likely source of the particular inhaled fibre which started the body's response process and led to the development of mesothelioma.
Do you want to run that past us again, please?
Certainly. We say, put very simply, the law achieves the right result within the limits of medical science. The position effectively as stated in Sienkiewicz, and I'll take my lady and my lords to that if necessary, still pertains. When any given individual may have many, many asbestos fibres in their lungs, no one can currently establish the likely or probable source of the particular inhaled fibre which started the body's response process, which led to the development of mesothelioma. So one knows that an individual has an asbestos disease, but one cannot pinpoint from what particular source the fibres came that started that process. So, again, forgive me for the barest thumbnail of the current position of the law, neither but for causation, the traditional test, nor material contribution avails claimants in that position. So, where we have a tortfeasor who is in breach of duty, the principled position taken by the House of Lords and the Supreme Court is that the tortfeasor, in breach of duty, who exposes claimant to asbestos, is liable if that tortious exposure gives rise to a material increase in risk. That's a unique causation test for mesothelioma claims, arrived at through the process, as I say, of Fairchild, Barker, the Compensation Act, and Sienkiewicz. Perhaps the clearest exposition of it is, if I may take you to start with to look at Sienkiewicz itself, to illuminate that point. It is at tab 21 of the authorities bundle, and therefore I suspect falls within what may be bundle 2 for my lady and my lords.
The cut-off is 19.
Thank you.
19 is the first one in the second, or certainly it's the second, first one in my second.
Extremely helpful, my lord, and I shall put a sticky note to remind me. We're in bundle 2. I'm very grateful. So behind tab 21 we have the appeal cases report of Sienkiewicz and Grief and Wilmore and Knowsley, 2 consolidated appeals considered by the Supreme Court in 2011. And if I may, I'll take the court directly to page 501 of the bundle, which is page 269 of that appeal cases report. And this is the judgment of Lord Phillips, President of the Supreme Court. And if I may take the court to paragraph 107 and 108. And again, I anticipate the process may be that my lords and my lady would prefer to read that than have me read it to you.
You may even have read it. And if my lords and lady have read 107 and 108, may I take you over, please, simply then to look and read paragraph 111, which is on the next page 502 of the authorities bundle. Perhaps it is worth reading this passage out loud. Lord Phillips says, "The reality is that, in the current state of knowledge about the disease, the only circumstances in which a court will be able to conclude that wrongful exposure of a mesothelioma victim to asbestos dust did not materially increase the victim's risk of contracting the disease will be where that exposure was insignificant compared to the exposure from other sources." So that, of course, gives rise to what is the question of what is a material increase in risk, what is perhaps described as a de minimis increase in risk, which would not give rise to liability. And as I indicated to the court earlier, that, of course, becomes a more acute and focused question now in relation to low-dose asbestos cases.
To what extent do you say that Lord Phillips there, and perhaps others in the Supreme Court, thinking of Lord Brown in particular, were laying down a principle of law that one identifies a material increase in risk by reference to the increase in exposure?
We simply say that that's the only logical reading of what's said there. Exposure, it is exposure that gives rise to risk. It's dose. Dose can be a proxy for risk. Dose and exposure can be considered to be the same thing. The amount, the volume of asbestos fibres to which one is exposed.
Because as I understand it, we got this wrong, but that's basically what you're calling method 1, isn't it?
Yes, yes.
I'm interested to know to what extent that is either said to be, or is the principle of law one gets out of Sienkiewicz, or is just the way it was done in that case. The broader test being as put at 107, I think, which is about material increase of risk without reference to exposure.
We read Lord Phillips as the test is material increase of risk. But Lord Phillips has described that that is to be done by considering exposure. And we respectfully submit that that's probably the logical way it has to be done.
It's it's the basis on which courts have proceeded since. And it is the basis on which, for instance, I'll take the court to it in due course if I may, if I can find it again, Hodgson and Darnton identify that exposure is best measured as risk. Sorry, risk is best measured as exposure. But for the purposes of my Lord's question, what is required is a comparison of the risk absent the tortious behaviour and the greater risk due to tortious behaviour. And we say conventionally, and in line with paragraph 111 and Lord Phillips, that's done with regard to dose and fibre dose and the degree and extent of exposure. Otherwise, I'm happy we can close the authorities bundle for now. We'll come back to it shortly. But if I may, in the next couple of moments, I'm going to take my lords and my lady through parts of the judgment, again noting that the court will have read it, hoping simply to pick out and illustrate a couple of points as I do. The claim was, of course, brought by Alexander Johnstone, who lost his wife Elaine to pleural mesothelioma. I'll pause for a moment and note, simply to note in passing, there are differences between at least two different kinds of mesothelioma, pleural and peritoneal, regarding where the tumour grows in the body, but also in respect of the medical understanding of how each suffered and how likely they are to be caused by asbestos exposure. So pause and flag that, and I'll move on if I may. Elaine died in August 2019 when she was 73, and but for the mesothelioma, she'd have survived another 14 years, probably. She was employed by the defendants. Again, forgive me, I'm skating through our skeleton because I know the court will have read it. She was employed by the defendants for about 7.5 years, between the early 1980s and the very late 1980s, perhaps early 1990. These are matters accepted and recorded in the judge's judgment below. This, exposure to asbestos during Elaine's employment with the defendant, was her only known exposure to asbestos. Other aspects were canvassed in the defence, that perhaps she'd got some from her father's work clothes or from army premises in which she may once have lived, but those were not found by the judge. The judge concluded this was her only known exposure to asbestos. The defendant, Fawcett's garage, is still in operation. It's still there. We have a rather historic photograph of it at the final page of the supplementary bundle, page 350. Or rather, we have a photo of the frontage of it, and we can see that it's a small high street garage in Newbury, a showroom big enough to have perhaps 1 or 2 cars on the street front, and an archway through which customers proceed to a small yard, to one side of which there's a mechanic's bay, to the other side of which there are offices. The office, the judge found and recorded, was 8 yards. So the judge curiously says 25 feet. I make that 24, but 24 feet from the workshop. And we emphasise at the very outset some of the judge's relevant findings as follows. Paragraph 12 of the judgment: unsafe practices were in use in the workshop, in that during the servicing of cars, an air line was used to blow out dust and asbestos fibres from existing brake shoes and clutch drive plates, as well as these asbestos exposures flowing from processes applied to new ones being fitted. For the fitting of new brake shoes, a grinding machine was used, or they were manually filed to size. And those two processes, plus the airline and the blowing out, liberated asbestos dust into the air. If it assists, I appreciate the court may be reaching for the judgment itself. It's at tab 11 of the core bundle. And the judge makes those findings at paragraph 12. The judge made some other findings as well. He found that the asbestos fibres with which this claim is concerned are chrysotile,
because that was the type used in brake and clutch assemblies at the material time. That's paragraph 16 of his judgment. At paragraph 82 of the judgment, the findings of fact are dotted around in a rather unusual way, but at paragraph 82 of the judgment, he recorded the following. He said, chrysotile asbestos is recognised to be of substantially lower potency in inducing pleural mesothelioma when compared with amosite or cricidolite, two different kinds of asbestos. That's paragraph 82 of the judgment. Now, we'll come back to this in more detail later, but we say the learned judge's use of the word substantially, that is, that chrysotile is substantially less potent than the other two kinds, was unjustified in the circumstances, and it didn't reflect the evidence. And again, skating over things in a way which I hope is not too light. It has been suggested in some medical papers and research papers that there is a potency ratio or a mesothelioma risk of 1 to 100 to 500, respectively, for chrysotile, then amosite, then cricidolite. Indeed, the judge referred to that ratio at paragraph 54 of his judgment. But that's a ratio which has been deduced from research into high exposure cases. The dock workers, the laggers, the joiners that we referred to earlier. The evidence the court had from Professor Norrie, who is the claimant's epidemiologist, he told the court, and the judge recorded at para 54 of the judgment, that the ratio for environmental exposure of those different fibre types is much more uncertain. And Professor Jones, who was the defendant's toxicologist, gave evidence that how much less potent chrysotile was is a matter for genuine debate. This is important because the judge, of course, proceeds on the basis that Elaine's exposure to asbestos would have been predominantly to chrysotile, although we will see that it's often contaminated by other asbestos fibres. And therefore, he went down, or was taken down, we say a totally incorrect route of assuming that he could work out a material increase in risk simply by a focus on chrysotile. And we say that's wrong. But what is clear is that nobody in the trial...
Which ground is that? Speaking for myself, one of my concerns about the first part of the skeleton is that there are a number of criticisms of the judge that I couldn't see were then later developed under the grounds.
It's, forgive me, the best place it fits, and I do say it fits, is under ground 1, whether the judge accepted or rejected.
I don't think, in fact, in the skeleton it crops back in.
We haven't, forgive me, my Lord is entirely right, we haven't alluded to the one.
So it's a bit difficult to catch these things in a net. We do rather rely on the skeletons to do that. There are a number of different points that are made about the judgment where, again, speaking for myself, I've written "so what" in the margins because it was unclear from the skeleton how that was then said to go to any of the actual grounds. So I make that point in relation to this first reference.
That's very helpful indeed, my Lord. I'm very grateful for the point. I'll explain how we come to it when we come to look at ground 1. But in the barest of summaries now, it is essentially that we say Professor Norrie told the judge, and the judge accepting the thrust of his evidence, he being the only statistician, the judge should have concluded that it was simply not possible, in this case, to extrapolate from the Hodgson and Darnton papers to conclude that chrysotile was so much less potent than others.
Okay, well,
So that's where the point plays in. Forgive
anyway,
me.
so you say this is relevant.
Part and parcel of the ground one.
Okay.
But I thought you seemed to be trying to get in by a side wind. The last point you were making immediately before my lord spoke, which is that it wasn't simply chrysotile. Are you? Because I understood, but I put it no higher than that the judge was proceeding on the basis that the exposure was chrysotile. Are you now seeking to undermine that?
No, the judge accepted. Sorry, it's not exclusively correct. Forgive me, let me try that again. It's the point I'm immediately coming to. If my lady has the judgment at paragraph 82, Romans 7, page 134 of the core bundle, the judge found that chrysotile contains tremolite, a more potent amphibole form of asbestos.
Yeah.
It's important. So forgive me, not all chrysotiles are the same. That's an awful way of describing it. But that it is impossible, the judgment in paragraph 16, let me get my copy of the judgment and take my lady back through it if I may. Paragraph 82
Yeah.
on...
It's 82 little Roman 8 is the substantially lower potency point you draw attention to.
Yes, 82 Roman 7 is the point that the asbestos in drum brake and clutch linings was chrysotile, albeit commercial chrysotile, generally contained tremolite, an amphibole form of asbestos. And if I may take the court back to paragraph 16 of the judgment, as I say, the judgment does slightly dot around. Page 109 of the core bundle, paragraph 16 of the judgment, the judge said, "It is unnecessary to describe in any detail the different types of asbestos, because the evidence is that the asbestos fibres with which this claim is concerned are chrysotile, also known as white asbestos, because this is the type that was used in brake and clutch assemblies at the material time." He goes on, though, as with other aspects of this case, there is some uncertainty about the extent to which the chrysotile asbestos will have contained traces of tremolite, a more potent form. But this is not a matter that the court is in a position to resolve to any absolute extent. I merely note it was a consideration raised during the trial, but on to which the experts were alive and was accounted for. Forgive me, I'm simply setting in context that when one talks about chrysotile from brakes, linings and clutch assemblies, one's not simply talking about a pure single fibre. There's
And
an
that is as narrow the point as you're taking.
I'm simply observing that the judge knew and had on board that not all chrysotile dust was the same. Some would be more potent than others, depending on how much tremolite was in it. Forgive me, let me return to my narrative very briefly, if I may. The defendant admitted breach for its unsafe working practices. And the judge recorded at paragraph 13 of his judgment that the effect of using an airline, hand file and grinding machine in the manner described was to produce clouds of dust containing asbestos fibres. So therefore the central issue on liability in this case is whether that admitted breach and the creation of that dust created a material increase in the risk of Elaine, who was not the mechanic, did not spend her entire working day in the mechanic's bay, the risk of her developing mesothelioma. And we say that is the correct test, but the judge looked at the wrong evidence and therefore came to the wrong answer. Now, the judge identified certain times when Elaine would have been exposed to asbestos, and he's identified those at paragraph 102 of his judgment, numbered Roman 1 to Roman 5. But the learned judge failed to adjudicate at all on the claimant's argument below that at all times while Elaine was working there, there would have been an elevated background level of asbestos. That is, That is to say that the amount of dust previously present, the blowing of it and releasing of it into the small courtyard, occasions when her door was open and dust would have come in, occasions when the mechanic, in his dusty work overalls, came into her office, would itself have produced an elevated background level of asbestos. I'll come back to that in due course, because you will see that that was not specifically taken account of in the expert occupational hygienist evidence. And the judge, despite Mr. Swoboda's invitation to adjudicate on that and to take account that, simply didn't. It doesn't appear in his judgment at all. Moving on one step, if I may, in my argument, what did the court do determining the claim? The court recognised that there should have been an issue. Forgive me. The court recognised the claimant's primary submission was about the correct methodology to determine the increase in risk of mesothelioma. And if the court has had even the shortest opportunity to look at the written closing submissions, it was clear to the judge that the claimant submitted, if method 1 was adopted, that was dispositive of liability, because on any factual finding open to the court, there would have been a material increase in risk. My lone friend Mr. Swoboda will elaborate on that point, and I'm therefore only introducing it now. So we say the court was invited to adjudicate on the correct methodology and was presented by the claimant and the defendant with a binary choice. Will the court assess the increase in risk on what we've called method 1, that risk is proportional to dose, or would it adopt the defendant's method 2? May I take the court, just to illustrate, in case the court has not had the opportunity to look at the skeleton submissions and understand the relative difference in position, may I take you to the claimant's closing written submissions, which are in the supplemental bundle behind tab 3. Starting at page 63, I hope. Perhaps in the interest of saving time, I won't read to the court, and I won't necessarily invite the court to read the first couple of pages, but it is absolutely apparent from those, my lord and my lady will see, the dispositive issue on liability, the two methods to increase risk, two methods offered to the court by the parties, claimant's counsel contends. The first method is risk is proportional to dose. We see reading over from pages 1 to 2 of that skeleton. Suggested that paragraph 4, method 1 represents the status quo. As my Lord Justice Zacaroli said, we do indeed refer back to Lord Phillips there, implying that risk is proportional to dose. And that, we say, underpins, or counsel contended below.
It's referred to as an implication.
It's an implication. It is because one reads together paragraph 107 and paragraph 111 of Sienkiewicz, Lord Phillips.
Yeah.
And it's difficult to see what else could be done, we say. My learned junior pointed out below at paragraph 5 that method 2 was an approach that, as far as he was aware, had never been adopted before. And we see at paragraph 6 that he suggests correctly the defendant was seeking to adopt method 2 because the defendant was suggesting that Elaine's occupational exposure was to chrysotile and therefore less potent, the defendant contended, than her environmental exposure. But it was contended below, it was a misuse and a misrepresentation of the scientific literature to suggest the occupational exposure was less potent than the environmental because all chrysotile is contaminated to varying extents, the point my Lady Justice Davies picked up on a moment ago. The fibre mix in Elaine's environmental exposure, which is the comparisons, my Lord Justice Zacaroli said, what was the exposure to asbestos? How dangerous was it? What was the risk? Risk is the best word. Bar the tortious exposure. And what is it in light of the tortious exposure? And it was pointed out again to the judge, one sees at C in paragraph 6, the relative potency of chrysotile to other forms of asbestos remains scientifically controversial, especially at low levels of exposure. And there are a number of other factors, such as fibre length, genetic predisposition, the synergy between fibres, and so on, which affect any individual's response to fibres. But one sees, may I take the court over, if I may please, to page 65 of the bundle. And again, given that these were my learned juniors' submissions below, I'll do my best to illustrate them so the court has them in mind as we proceed through the rest of the argument. If I get them wrong, I'm quite sure they'll be clarified in due course. But this is how method 1 works. We see in tabular form, Raymond is the mechanic working in the mechanics bay. And there was a dispute between the two occupational hygienists, Mr. Chambers for the claimant and Mr. Steer for the defendant, over whether his dose could be calculated. And this is the metric for it, is 1 fibre mil year, according to Mr. Steer, the defendant's expert, or 4.71 fibre mil years, according to the claimant's expert. And we see that Mr. Swoboda then tabulated out for the court how the left of the two columns to the right, it would work if one were to take the 1 fibre mil year, which is Mr. Steer, the defendant's expert's view of Raymond's exposure, and how it would work out if it was 4.71 fibre mil years.
Can you just help me with what fibre mil year means in English?
I'll do my very best. It's a concept that we use, but fibre mil is a measure of the number of fibres in the air, in any given volume of air. And fibre mil, milliliter, yes. And fibre mil year is a measure of exposure over what is taken to be a working year. So it's a 48-week year, I think, of 8 weeks, 8 hours a day, 5 days a week. So fibre mil year is a cumulative concept to describe how much asbestos a typical employee is exposed to in a typical year. It effectively combines any given moment, what might be in the air you breathe in, with for how long over the course of a year you're exposed to it.
So is it essentially, it's not obviously saying this happened, but it's to be equated as if there had been 1 fibre per milliliter in the air for the course of that, throughout that year?
Yes, that's what 1 fibre mil year equates to, yes.
Yes, thank you.
Yes, sorry. And you will see that the issue between the occupational health experts was that, calling 4.71 roughly 5, the claimant's expert thought that the mechanic had been exposed to about 5 times as much asbestos as the defendant's expert concluded they had been. There are issues in that over their respective positions on how many days a week the mechanic worked with asbestos. That's the main underlying distinguishing feature between those two. But forgive me, coming back to the chart, if I may, what one sees plotted out is if Raymond the mechanic was exposed to either 1 or 4.7, then Elaine, who was occasionally in the mechanic's bay, walking across the yard, Raymond was occasionally in her office with dusty clothes. Again, there are further estimates based on the difference between the claimant's and the defendant's occupational health experts. Mr. Chambers considered that Elaine's dose would be about 5% of that which the mechanic was exposed to. Mr. Steer for the defendants considered it was about 0.15% of the dose that the mechanic was exposed to. So again, what we see, my lords, in those ascending family trees or increasingly broad spreadsheets of columns is how that features through. So what one then considers is environmental exposure. This is the traditional way of method 1 we suggest. And one sees there plotted across what each expert considered was the fibre exposure from the natural environment outside. What one then arrives at is a level of increase in risk. So what one sees is, let's take the column to the left. For these purposes, we are assuming that Raymond's dose is the lower end of Mr. Steer, the defendant's expert's figures at 1 fibre mil year. We're assuming for, again, to the left of the next column down, that Elaine's dose was 0.15% of the mechanics exposure. And we're assuming again in the next column down that the occupational exposure is the greater figure. So there is a lower, environmental exposure is the greater figure. I'll say that again because I've confused myself. The occupational exposure for Elaine comes to 0.0015 fibre mil years. The best figure for the defendant was that her environmental exposure was 0.046 fibre mil years. So a greater exposure outside work, outside the tortious work, than the claimant's expert said. But even on that basis, one gets to a 3% increase in risk comparing her occupational exposure against her background. And that's the worst case. My lords will appreciate, my lord, my ladies will appreciate, as we look at the figures in a different way, the levels of risk increase. And plotted out, mathematically, this is how it is. If the judge goes down the route of approaching the case on that method 1 basis, the least increase in risk is 3%. And clearly we say that's not de minimis, that is material. There are plenty of authority for figures of that sort of level being material. And we say, therefore, claimant succeeds on method 1.
The authority that's identified, CARDA,
Yes.
that was a concession rather than a finding.
It was a concession rather than a finding, but in terms of industrial disease and the apportionment and contribution between tortfeasors and the apportionment of different periods of employment to those diseases which are cumulative and divisible, one regularly sees in practice, and I can put it no higher than that, responsibilities of one.
But we're looking at the submissions that the judge had.
Yes.
And the case that's identified
is
a case where it's a concession rather than a finding.
That is correct. That is correct. I don't understand that it's only part of the defendant's position to say, today to say that a 3% increase in risk is de minimis. I don't understand the defendants today to be arguing that a 3% increase in risk doesn't get a claimant home.
Well, Lord, I'm not sure my friend can bank that. I don't think I need to go there, but a 3% increase in a tiny original risk may well be de minimis.
Well, it's certainly something that's in your skeleton. I think you say 2 to 3% is the actual figure in your skeleton. But I wasn't anticipating that Mr. Snowden could bank it. But it's just getting where the battle lines are. That's all. Yeah. No. Well, I understand that submission. We understand that submission. You say 3%. That's not. Even if that's the worst case, that's not de minimis.
Indeed. Exactly so.
Understand that.
Exactly so. And it would be. We'll have to see how my learned friend develops it if he does. But we would say it would be striking and surprising that a figure which is greater than 1%. We say notionally. Sorry, I'm speaking off the cuff without thinking about it much further, but something measured in the 3s, 4s and 5%, the risk is a material increase. I'm not sure I understand my learned friend's point when he says a 3% increase of what's already a small risk. It's the material increase in risk that we look at in Sienkiewicz. It doesn't matter how low or how high the starting point is. It is at a material increase from whatever point we start at. Anyway, that's method 1 in practice, as was set out by Mr. Swoboda for the trial judge. If I may take the court over to page 72 of that bundle, page 10 of Mr. Swoboda's submissions.
Mm-hmm.
This is how method 2 appears to us to work, which is that one identifies the occupational exposure for Elaine. Now again, that's 0.0015 or 0.24. But what one then does, instead of comparing it with exposure in the normal environment, away from the tortious workplace, is one seeks to try to turn that level of exposure into a statistical risk of death, relying on Hodgson and Davies' paper and extrapolating from it, it being focused on peer review of other literature dealing with high exposure cases. One of the key issues in this case is, as the court knows, is it at all appropriate to extrapolate down to very low exposure without any further information from numbers and data that are arrived at in high exposure cases? And what method 2 does is it turns the occupational exposure into a risk by saying how likely is that level of fibres to lead to death. It does so by extrapolation from Hodgson and Darnton. And in this case, it's focused only on chrysotile. It takes the chrysotile figure from Hodgson and Darnton. And what the defendants then do is they say, well, look, here's a different study, Peto and Rake. This tells us about environmental and idiopathic risk. That is, it's still believed there's a small number of individuals who suffer a pleural mesothelioma without asbestos exposure at all. There are some who suffer it from their environment but don't know it. Without frightening the court, we all inhale asbestos fibres in buildings of this age, for instance. It's all around us. And for some, there might be exposure in a workplace that wasn't recognised as having been workplace exposure. So Peto and Rake assessed that, but they didn't break their figures down into those to do with chrysotile or those to do with more potent fibres. So what the defendant then seeks to do is to compare the extrapolated risk of death from mesothelioma from Hodgson and Darnton, derived from an occupational exposure fibre mil figure, with the Peto and Rake figure, a much broader analysis, an analysis of much broader exposure to a broader range of fibre types. By comparing those two, the defendant, you, my lords will see, drives the figure down to 0.04% increase in risk. So the nub of the argument below, the nub of this appeal, is whether it's method 1 or method 2. Whether method 2 was ever open to the judge, which we say it wasn't, as my lord and lady will have gathered. For a number of reasons, my own friend Mr. Swoboda will, Junior Mr. Swoboda will elaborate on those when he comes to grounds 2, 3 and 4. But again, I hope in sketching out that background of the difference between method 1 and method 2, the relevance of chrysotile, the fact that the studies were concerned with different things, the degree of extrapolation required from Hodgson and Darnton down to low-level exposure cases. I hope my lords and my lady have a sort of a sketch, an idea of the territory that we're navigating our way through in this case. And I hope those tables are helpful. I don't think I will take you to the supplementary bundle again for at least a few minutes. Now, it is entirely correct that paragraph 86 of his judgment the judge in the 5th or 6th line down in paragraph 86 responded to that submission by saying there is no authority for the proposition that this, that is method 1, was the only acceptable way in which to determine an asbestos-related claim. That might be right, but if so, it's not probative as to whether method 1 or method 2 should have been adopted. That was still a matter for the judge to decide on the evidence before him. And secondly, the learned judge, we say, misunderstood Malone Junior's submissions, which were that method 1 represented the status quo, not that it was necessarily binding. It's what people would do. It's what people do in light of, as my Lord Justice Zacaroli observed, what Lord Phillips said in Sienkiewicz. So, strictly correct, no binding rule But what that didn't do was mean the judge was entitled to choose one over the other without a reason, or without good reason, or contrary to the evidence. And as my learned junior will no doubt develop in dealing with grounds 2, 3, and 4, no part of this judgment considers or criticises method 1, nor compares method 1 and method 2 to identify where method 2 is to be preferred. The judge simply makes some observations and proceeds with method 2. So again, failed to grapple with those issues. As it was, the judge, in moving down method 2, adopted an approach to the evidence from the defendant's occupational hygienist, which moved away from assessing Elaine's exposure as a percentage or a proportion of the mechanic's exposure. And instead, seemingly without evidence, in his second report, Mr. Steer, the defendant's occupational hygienist, has said, let's assume Elaine is exposed for 5 to 10 minutes a day. Now, there is no evidence that she was exposed for only 5 or 10 minutes a day. There's no evidence on the duration of exposure at all. So again, in preferring the defendant's occupational hygienist, and therefore in going down to the route of method 2, we again, if you'll forgive me this expression, we poke holes in the assumptions the judge made to underpin.
Sorry, Lord, I reticent to rise, but there's no appeal against the findings of fact of the...
I'm very aware of that.
That's why I used that expression sidewind a little earlier.
Sorry. I'll move on.
So that it's clear, my current understanding is that the only appeal in relation to the levels of exposure is effectively ground 5. The adverse inference.
Yes.
Which is presumably why you're taking the, if I may say so, very sensible decision of dealing with that first, because that goes to that. All the other grounds go to the key point, on the appeal at any rate, which is the material increase in risk.
Yes, even given that level of exposure, given the judge's finding. That's entirely correct. Well, let me jump then straight to ground 5, if I may. And I'll proceed through it as swiftly as I may. Summarising, our ground 5 is that the judge should have drawn an adverse inference. And when we say adverse inference, we say the judge should have preferred the evidence of Mr. Chambers over that of Mr. Steer, because the judge found himself in the position of having to decide between Mr. Steer and Mr. Chambers, having to receive evidence on and adjudicate on all aspects of Elaine's occupational exposure, wholly or substantially because the defendant was also in breach of duty from failing to undertake air sampling.
Sorry, failing to undertake?
Air sampling of a work process that involved exposure to asbestos. This is a point drawn from the 1987 regulations, which I'll take the court to in a moment. But we say from at least, the judgment records, and there's a concession in closing submissions, as I understand it, for at least the last 12, perhaps 18 months of Elaine's employment, air monitoring, air sampling ought to have been undertaken by the defendant. That would have identified the fibre mill exposure for the mechanic. It would have saved the parties having to adduce contentious, different evidence as to the mechanic's probable exposure, from which then to deduce Elaine's probable tortious exposure. So the defendant was in breach of statute by failing to have those records for at least the last 12 to 18 months of Elaine's employment. that material, had it been kept, would have been demonstrative, probative of the mechanics level of asbestos exposure. It would have taken a whole layer of calculation and speculation away from the judge. So, may I take you very briefly, if the court's looked at some of the authorities, I'm happy to take you to the authorities on drawing inferences, if I may. There are two in the bundle. The first is Mackenzie and Alcoa Manufacturing. And that is in the first authorities bundle at tab 10. When I say the first, it's the first in the bundles. It's in fact the second in time. I'm going to take the court back in time to the case of Keefe, which preceded it, in a moment. But in the Mackenzie case, Lord Justice Dingemans reviewed the authorities and distilled some principles, and I'll take the court to those in a moment. But it's important to understand what Mackenzie was. It was a noise-induced hearing loss claim, which is the individual asserting that they'd been exposed to unacceptably large levels of noise at work, as a result of which they suffered occupational deafness. On the facts of that case, the employer had not carried out any noise surveys. But the first instance trial judge, forgive me, I've overstated it. At the time of trial, there were no noise surveys available. And there were therefore no noise surveys available to assist the experts to identify the claimant's exposure to tortious levels of noise, if any. But the trial judge took a sympathetic view to the defendants and said he wasn't satisfied that none had been done. He thought it just as likely they may have been done and lost. So the defendants in this case, Alcoa Manufacturing, were not necessarily in breach of duty in failing to carry out, or failing to still have, noise assessments. There was also an issue in this case as to whether, even on the expert evidence, they were in breach of duty in the sense of, was the exposure to noise tortious, sufficient to cause liability? Now, we say that's a very different kettle of fish to Keefe, which we'll look at in a moment. It's a very different kettle of fish to our case, where in both Keefe and our case, it's clear that in Keefe noise assessments, and in our case air sampling, should have been carried out, and the defendant is therefore already in breach of duty by failing to do so. And moreover, in our case, unlike the underlying facts of Mackenzie, it's clear that the defendant is already in breach for asbestos exposure, whereas in Mackenzie it was still all to play for. So on the facts of Mackenzie, the court declined to draw an adverse inference, but it is distinguishable because they were not necessarily in breach of duty in failing still to have those documents, and because they were not otherwise already in breach of duty or established to be in breach of duty towards the claimant. But may I, with that background, may I take you to the judgment of Lord Justice Dingemans, who, but for a short addition from Lord Justice Bean, gave the judgment of the court. And essentially we start, may I start at paragraph 50, and then I'll take the court back to two others if I may. Paragraph 50, Lord Justice Dingemans says this, having reviewed the authorities. It seems that, excuse me, forgive me. It seems therefore that it is possible to state the following propositions. First, whether it's appropriate to draw an inference, and if it is appropriate to draw an inference, the nature and extent of the inference would depend on the facts of the particular case. See Shaw-Lincoln, which he refers to at 47 above. Secondly, silence or a failure to reduce relevant documents may convert evidence on the other side into proof. That may depend on, go over the page, the explanation given for the absence of the witness or the document. See Harrington, Keefe at paragraph 19, and Petrodel at paragraph 44. It's the conversion of evidence into proof as the penalty for failing to adduce material that I really want to focus on for the court, if I may. And if we go to the previous page, 236, and to paragraph 43 of the judgment, we see what Lord Justice Dingemans traced the origin of an inference being drawn and quite how serious it could be. And it's noted by Lord Justice Dingemans without criticism. It's a 1721 case called Armory and Delamarie, where the court approved a direction to a jury to infer and to find the highest value consistent with the jewel as described in the evidence, which had been given to a pawnbroker by a chimney sweep and refused to return. So one infers, one can only understand that in that case, there was a dispute over the value of that which was lost. Somebody declined to produce it, and it was converted into evidence in the sense of the court properly directing without criticism that it be given the highest value. So we say that's the context in which Lord Justice Dingemans says at paragraph 50, which we've just looked at, the failure to adduce relevant documents may convert evidence on the other side into proof. So we say the court would be entitled, and this trial judge could and should have said, you, the defendants, have put us in the position where we should have known what the mechanic's asbestos exposure was. You're already liable in the sense that it's accepted in breach of duty you expose this claim to asbestos. You're liable in the sense of being in breach of duty for not having those documents to put to the court. Therefore, I should, in a sense, penalise you because you've created an evidential difficulty for the claimants, and therefore I should prefer the claimant's evidence. That's consistent, we say, with the reading of these cases. May I take you to follow up and stay in the authorities bundle, although it's bundle 2, I'm so sorry, bundle 2. Tab 22, we have Keith. And within that authority, if the court's with me behind tab 22, we should have the Court of Appeal decision on the appeal of Keith, Lady Justice Arden, Lord Justice Longmore and Lord Justice Aikins. The sole judgment, I think, yes, the sole judgment's given by Lord Justice Longmore. I'm going to take the court to paragraph 19 in a moment, but it's probably prudent to start before that at paragraph 18 on page 541, where Lord Justice Longmore has reviewed the evidence in the case below. And he says this: if matters had rested there, that was on the oral evidence that there was in the court below, it might have been difficult for this court to reverse the judge on what is, at any rate, primarily a question of fact, namely whether excessive noise in the course of Mr. Keith's employment caused his undoubted hearing loss. However unsure the court might be that the judge had reached the correct conclusion. But, Lord Justice Longmore goes on, in the present case, there is the potent additional consideration that any difficulty of proof for the claimant has been caused by the defendant's breach of duty in failing to take any measurements. The judge does not appear to have given any weight to this important factor. If we may then skip on to paragraph 19, the paragraph that is redlined, Lord Justice Longmore says this: if it is a defendant's duty to measure noise levels in places where his employees work and he does not do so, it hardly lies in his mouth to assert the noise levels were not, in fact, excessive. In such circumstances, the court should judge a claimant's evidence benevolently and the defendant's evidence critically. Then goes on, and perhaps if I can take the court simply to the next paragraph. Sorry. Let me take you to the end, the final sentence of paragraph 19. Similarly, a defendant who has, in breach of duty, made it difficult or impossible for a claimant to adduce relevant evidence
must run the risk of adverse factual findings. To my mind, this is just such a case. And my lords and my lady will have in mind that we say our case is identical to, in material detail, the case of Keith. But Lord Justice Longmore then goes on to say this has been accepted law since Armory and Delamere, the famous case in which a chimney sweep found a jewel in a chimney, left with the pawnbroker for valuation. The pawnbroker in breach of duty failed to return it, could not be heard when sued. To assert the chimney sweep could not prove its value. The court awarded the highest sum realistically possible. So, in this case, Lord Justice Longmore in the Court of Appeal is condoning and endorsing an approach of looking benevolently at a claimant's evidence and critically at a defendant's evidence when, in breach of duty, the defendant has, in a sense, pulled the rug from under the feet of the claimant by not keeping records which would establish that which the claimant has to prove.
What was the claimant's evidence in this case that should have been treated benevolently?
In this case, the claimant, in the Keefe case, the claimant...
No, in our case.
In our case, it's the evidence adduced from Mr. Chambers.
So it's expert evidence.
Expert evidence.
Right.
Yes.
But this is a question of fact.
This is a question of... excuse me. In a sense, it matters not in Keefe whether it's a question of fact or whether it's expert evidence. What the experts in our case are doing are trying to enable the judge to make findings of fact about the level of exposure that Elaine was subjected to in breach of duty.
But I don't think the records that should have been kept would have shed any light, would they?
They would.
On the extent of the deceased's exposure as compared to the mechanics exposure.
Absolutely accept, not directly. But what the judge had to do, and my lord saves me having to go through the next 2 or 3 paragraphs that I had here, the judge had to start from scratch and have guesswork or estimation. The judge himself had to make assumptions about what a witness said when he said he worked for a day a week on brake linings. Was that one single whole day? What was the nature of his exposure from that? The judge had to make those sorts of findings. Had the defendant in this case conducted air monitoring, we would know over the typical week, over the typical month, over the typical year, the extent of asbestos exposure the mechanic had. So the whole layer of primary argument and speculation and evidence from occupational hygienists would not have been required. There would have been hard data for the exposure level of the mechanic. Instead of both parties having to produce evidence and the claimant therefore inevitably being at a disadvantage, we say.
Yes. So I think your submission is, in this case, the only evidence of the days that the mechanic worked were his evidence.
Yes.
And because records weren't kept, the judge should have assumed it was more than that witness said. But what you don't have, I think, is any evidence from the claimant that actually he worked more days.
No, we don't. No, we don't. But what... Forgive me, let me try to explain this again. It's my fault for not being clear. What if air monitoring records have been kept? We would know, for that period for which the records were kept, what the mechanic's, effectively, what his fibre mil year exposure was. So one whole layer of uncertainty on the facts, which both parties had to investigate through their experts, and which the judge had to determine, would have been unnecessary. So the defendant's breach in failing to have those records has introduced argument and uncertainty when it should not have existed. And we say in those circumstances,
when presented with two sets of different views from occupational hygienists, the judge ought to have drawn an adverse inference. Seems inept language for what we're talking about, but from the two cases we've looked at, we see that it is. The judge ought to have preferred the evidence put forward by the claimant, we say. Very much like the dual valuation. Clearly there were a range of values for the dual. The jury were directed to take the highest, the most favourable to the person who's been disadvantaged. So we say here the judge should have directed himself that in those circumstances where the claimant is disadvantaged, where there's an issue over the evidence, he should take that evidence which is most favourable to the claimant who has been disadvantaged by the defendant's breach.
Are you able to point us to precisely which bit of Mr. Chambers' evidence the judge should have accepted?
Well, my lord, I'll take you back to the tables we had at Elaine Junior's closing submissions, which are at page 65. You'll see that certainly in respect of Raymond's dose, this is the table for method 1. It matters not because the same figures, of course, appear in the starting figures for method 2. Where the Raymond's dose was 1 fibre mil year or 4.71 fibre mil years, according to Mr. Steer or Mr. Chambers.
Sorry, Mr. Stone, which table are you looking
Sorry,
at?
I'm back at the. Forgive me, my lord. I'm in the supplementary bundle. I'm behind tab 3. I'm at page 65.
So you're back in the submissions for trial.
I am, but I'm back to illustrate the point that my Lord Justice Zacaroli asks.
The table, I think, in the skeleton argument is different, but if this is illustrating this point, then that's fine. So this is the table at page 65
Yes.
of the bundle, under paragraph 7.
Paragraph 7. And our submission is this, that in light of the claimant being disadvantaged by there being no objective evidence because of the defendant's breach of duty in failing to keep their monitoring records, the judge should have preferred the evidence of Mr. Chambers that Raymond's dose was 4.71 fibre mil years, rather than the evidence of Mr. Steer that it was only 1 fibre mil year. And finally, if I may, to make the final aspect of this point good, may I take the court back to the judgment itself and to paragraph 89 of the judgment. So core bundle, I think tab 11, we're at page 136. The judge there says, to adopt Professor Norrie's terminology, the uncertainties in this case are legion for various reasons. This is the uncertainties about calculating the exposure. He goes on to say, in a non-exhaustive list, some are inherent uncertainties in relation to mesothelioma, its genesis, its incidence in the population. Some relate to asbestos, particularly ambient levels in the UK, as well as actual levels at the defendant during the relevant time, given the absence of any on-site monitoring. So the judge himself recognised that his decision was being given greater and unnecessary complexity, a further uncertainty being added, specifically because of the defendant's breach in not having on-site air monitoring records. So we say this case does fall full square within the principles of Keefe, that the defendant's duty was to measure. The defendant didn't measure. And in such circumstances, the court should judge a claimant's evidence benevolently and the defendant's critically. And the judge didn't. And we say that vitiates that part of his judgment. The reasons the judge gave, in brief summary, and I won't, in light of the time, and we need to move on, I won't take the court through them in any great detail, but they are set out in our skeleton argument, around about paragraphs 77 and 78. The judge said, there are some issues which will require judicial determination anyway. I mean, we respectfully, adopting my Lord Justice Coulson's red line writing, say, well, so what? That doesn't mean the defendant shouldn't be penalised and the claimant shouldn't receive the advantage of having to struggle against the situation the claimant found themselves in because of the defendant's breach in failing to have air monitoring records. Some judicial determination might have been required, but it would have been less. My Lord Justice Zacaroli is right that one would still have had to have an exercise on evidence by which the judge could conclude what Elaine's exposure was, but it would have proceeded from a sure foundation of knowing what Raymond's was. There would not have been the controversy and the extent of disagreement between the experts as to the foundational measure of Raymond's exposure. Simply, I'll move on, but I'll commend to the court, if I may, paragraph 77 to 80 of our skeleton below, where we our skeleton for today, where we elaborate on that point a little. And we say, in a sense, what is clear, and we say this in paragraph 81, if the court will forgive me for repeating it orally. By refusing to draw an adverse inference, the learned judge in fact conferred a benefit on these defendants for their breach of duty in failing to conduct air monitoring. That's the upshot of what happened. Because on the learned judge's approach, the defendant did better not having kept any records. Because if there had been records of air monitoring, that information could have been tested with the experts and would have informed any dose calculation for Raymond and for Elaine. And as it was, the learned judge instead drew inferences in the defendant's favour by, first of all, acknowledging it was unrealistic, suggesting it was unrealistic to reach any absolute exposure figure, but then doing precisely that, preferring Mr. Steer over Mr. Chambers. And we say, in light of the defendant's breach, he should have done precisely the reverse. So that, in a nutshell, is our appeal on ground 5.
So that I'm clear,
yes.
That means, if you're right about that,
yes.
then effectively the appeal would succeed because the figures would be Mr. Chambers' figures
yes.
for the mechanic extrapolated to Elaine
yes.
and therefore much higher than the judge found.
Not extrapolated to Elaine, but they would form the basis of a calculation.
Well, they'd form the basis
yes.
of the calculation.
Yes.
All right. So, and if you're wrong about that, then we have effectively, we get to paragraph 108 of the judge's judgment. The next question to be addressed is how this figure is assessed in terms of the test of material increase in risk.
Yes.
So that's...
Yes. Yes. Ground 5 is a win for
I'm
us.
cursed with one of those terribly logical minds where I have to work out what goes where. I know it's a pain, but I can only apologise.
My Lord is right. If we win on this, we win.
Yeah.
If we lose on this,
Then it becomes
we move on
material
down.
increase in risk becomes the sole
focus of
battleground. But various fights across that battleground.
whether the judge went wrong on material
Yeah.
increase.
Okay.
Yes.
So then you're going to address ground 1 and Professor Norrie.
I'm going to do that very briefly, I hope, and then pass over to Mr. Swoboda, if I may. Our summary is, ground 1 is in fact a short and simple one. The judge identified only some parts of Professor Norrie's evidence in his judgment, but not others. The judge asserted that he followed the thrust of Professor Norrie's evidence, but we say when one looks at it properly in its context and includes those aspects of the evidence which one can only speculate, perhaps the passage of 6 months between submissions and judgment had led to be marginally less clear in the judge's mind, despite the written submissions. The judge ought to have concluded that Professor Norrie's evidence as a statistician, which he said he accepted the broad thrust of, was one could not safely extrapolate from Hodgson and Darnton's data down to Elaine's exposure in this case, or Elaine's risk in this case. May I take my laws of my lady to one authority? It may be that I don't need to. I was going to take you to Henderson, as being that essentially the sort of things a judge should not do that will vitiate their judgment would be make a critical finding of fact for which there's no basis in the evidence, or a demonstrable misunderstanding of the evidence, or a demonstrable failure to consider relevant evidence. Those are all good bases to overturn a judge's findings of fact and vitiate the judgment. Otherwise, we set that out of paragraph 29 of our skeleton. It's based on the Henderson case in the Supreme Court. I don't need to, my lord and lady, require me to take you to that short paragraph.
No, it's in your skeleton argument.
It's set out succinctly in the skeleton argument. And my lord, simply then all I would do is, if I may, take you to skip very quickly between, in 2 or 3 places, between the judgment and the transcripts of evidence. We say the judge went wrong at paragraph 110, which is tab 11, core bundle, page 142. And if my lords and lady have that, if you'll forgive me one moment. The judge says this: I accept the thrust of Professor Norrie's evidence, which I interpret to be the exercise of significant caution when seeking to extrapolate down to low doses from H&D, Hodgson and Darnton's model equation. So the judge says he accepts the thrust of Professor Norrie. He then applies his own interpretation that he believes what Professor Norrie says is it's okay to extrapolate if you apply significant caution. And we say that's simply wrong. Nowhere in the evidence does Professor Norrie say that it is acceptable to extrapolate down to low dose, whether with significant caution or not. On the contrary, there are half a dozen references that I'm going to take the court to, if I may, as briefly as I may, where it's clear that Professor Norrie, while respecting the integrity of the Hodgson and Darnton paper, which is a meta-analysis of other papers dealing with high exposure. Pausing for a moment, again, depending on how my learned friend deploys it, we may look at Hodgson and Darnton, we may take the court to that in response, but the authors themselves recognise that their extrapolation down for low-dose cases is something of a hazardous exercise to be approached with great caution. And indeed, so does a paper from the Watch Committee that we refer to, the judge refers to, we refer to, and Professor Norrie referred to in his evidence. The Watch Committee is a series of capitalised letters, which I'm afraid I can't provide you the information of what they mean, but I will this afternoon if that's necessary. But it's a Health and Safety Executive Committee on which Hodgson and Darnton themselves were members, which cautioned about the use of that meta-analysis for low-dose cases. But let me summarise, and then perhaps just take you to the highlights of it. Throughout Professor Norrie's evidence, he considered that Hodgson and Darnton, while, forgive my shorthand, a decent paper doing what it did, a credible paper, a respectable paper doing what it did, that is a meta-analysis of other papers, he considered it, his expression, not fit for purpose.
Well, did he actually identify that paper as not fit for purpose or a particular type of model? Because there is a quote. It may be in the agreed expert's final statement. Frankly, I can't remember.
Let me take you, if I may. Let's look at... I notice page 261 and tab 18, so that must be the supplemental bundle. Forgive me, my lady, it'll just take me a moment to get that.
That's his evidence.
Supplementary bundle. And it is tab 18 and page 261, and if my lady will allow me to see whether that assists. Yes, I believe it does. My belief doesn't matter, I submit that it does. My lady will see here the preceding page, I don't think helps us say that it is obvious that this is Professor Norrie's evidence in chief on these pages. Yes, Professor Norrie's evidence in chief. So if we go back on to page 260, one sees some 5 or 6 lines from the bottom. Professor Norrie is specifically giving evidence in the context of discussing the Hodgson and Darnton paper. One sees in the sentence 1, 2, 3, 4, 5 lines up from the top, starting in the middle, I mean, what has been done here, and Hodgson and Darnton, even in the year 2000, were very, very explicit about the dangers of extrapolation. What's being done here is essentially the model is extrapolated in a kind of fairly simple way. I think my overriding point as a methodologist, as a statistician who has spent a considerable amount of time modelling all sorts of circumstances, trying to relate potential, exposure to harm, is that, it's very possible to underestimate or overestimate the risk, depending on how you deal with that extrapolation. And I think I would also add, although I do not say this in my report, that of course Hodgson and Darnton was a meta-analysis. It wasn't a structured experiment. And he then goes on to talk about how one might structure an experiment so as to make it reliable. Below, 2 lines below letter B on the left-hand side, because Hodgson and Darnton was just, they took what was available, by which I understand him to mean the previous papers that they were conducting the review of. And therefore, even within the Hodgson and Darnton range, you don't have a nice linear range. It would have been kind of concave and convex. I think he's talking there about the graph or the line of extrapolation that might be drawn. But what one sees at letter C is, again here, specifically answering my lady's question, in the context of discussing Hodgson and Darnton, it is a huge amount of uncertainty. I mean, I do not want to be melodramatic, but you probably could get pretty much any answer you wanted, depending on how you did the extrapolation. As a statistician, that is a very uncomfortable place to be. And then one sees, if I may take my lady down on the same page, following, and we say arising out of, the conversation about Hodgson and Darnton, and therefore imminently relatable to and absolutely descriptive of Professor Norrie's views on Hodgson and Darnton. By letter F, there's a sentence that again begins, I mean, honestly, I've never seen a situation where you're trying to confidently extrapolate 100 to 1,000 times below. That is extremely hazardous. And then at the bottom of the page, continuing...
Can you read the next sentence?
Certainly. And I've heard it say in many of the suppositions, many of the depositions, that, well, that is the best we've got. And I do sympathise with that. This is a very difficult area where, as I say in my introduction, there's very little high-quality data, that being low-dose exposure, or on even the exposures or indeed the outcomes, where there's lots and lots of misclassification issues, both over time and space. But there's not really any area of this where you can look at it and say there is really good data that we can all, put in the bank. But you've got to be careful with the argument about, okay, it's the best we've got and it's therefore safe to proceed. That is the inference. In lots of predictive modelling, if we go over the page 262, lots of predictive modelling, which in effect this is predictive modelling, it's just trying to predict back away rather than forwards. A useless model is as good as tossing a coin. That is a statistically accurate characterization. He then goes on to say, in my work, I wouldn't use a model that was close to useless. I would actually say to people, you might as well toss a coin, because in my experiences, people understand the risks of tossing a coin.
They will believe in the outcome of that much more clearly if you're effectively saying toss of the coin than if you're using a statistical model. So I think there is a psychological element to it as well. I sympathise with the argument that it's the best we've got, but I might argue that Marsh is better than that. But you still have to say, is it any good? It's not a free pass just saying it's the best we've got. So
It's a long way away from the question, which was to do with a lower level of extrapolation is less problematic.
he has gone some distance from the question, but forgive me, I took the court to that at some length as an answer to my Lady Justice Nicola Davies's question.
I can understand that.
Are we confident?
I can't help noticing that it was a very long and possibly non-answer to a specific question.
It might have been.
There it is.
It's a question.
Happily, it's a long time since I've done trials, so you don't have to worry about them. Yeah.
Apart from being deeply envious, I note my Lord's comment. But it is clear. We say it is abundantly clear that Professor Norrie was saying that while Hodgson and Darnton might be what one called the best we've got, it was not safe to extrapolate from it. This page and a half of evidence in my submission makes that crystal clear. And yes, the reference to tossing the coin, the reference of not being fit for purpose. My ladies, you have that. Really, we've set out the rest of the references through paragraphs 31 and 32, but if my lady's key concern was whether they really related to Hodgson and Darnton, I hope I've answered that.
Yes.
It's a hesitant yes, which I'm reluctant to leave standing.
It's all right. When I read the skeleton argument for myself, I didn't think it accurately set out what, in fact, Professor Norrie had said. But anyway, that's a matter of interpretation.
If I can assist my lady further, I'd be delighted to. But I hope
much.
taking you to these 2 pages puts it in its context, that it was a conversation arising from Hodgson and Darnton. And specifically, I suppose the most pertinent and directly proximate sentence to the Hodgson and Darnton name is that at page 261C, where there's a huge amount of uncertainty. You can get pretty much any answer you want depending on how you do the extrapolation. And again, one then sees his model as good as tossing a coin and so on. Now, again, the reference to not being fit for purpose is not to suggest that Hodgson and Darnton, as I say, wasn't a respectable meta-analysis of high-dose mesothelioma data. It's not fit for purpose to be extrapolated down to give the occupational risk for Elaine. And we say those words that he used, not fit for purpose, and the rest of the language that we've just looked at here, cannot logically or possibly be interpreted as meaning what the judge said. Use of significant caution, you can extrapolate down. That simply, we respectfully submit, doesn't withstand scrutiny. So the judge has, we say, fallen foul of the Henderson principle. He has plucked out for himself, mistakenly at paragraph 110, a reading of or an understanding of Professor Norrie's evidence, which has no basis in Professor Norrie's evidence, or is a demonstrable, I hope I've demonstrated it, misunderstanding of Professor Norrie's evidence.
Is this all that Professor Norrie said about the question? What you've shown us?
No, forgive me, I've skipped rather lightly, in light of the time, over the references that we've put. Paragraphs, if it helps in my Lord's note rather than reciting them all, but paragraphs 31, 32, and 33 and 34 of our written skeleton for the appeal. The references include he'd never seen extrapolation down 100 or 1,000 times from reliable data. Cautioned against accepting that it was the best we've got, so it's safe to use. His expression, a useless model is as good as tossing a coin. I don't want to be melodramatic, but you could get any answer you wanted depending on how you did the extrapolation. Not fit for purpose.
What I meant was, do we find all these only in that passage of cross-examination you showed us?
Is there any other material we should look at?
There is in the final statement, the agreed statement from the experts. If one looks at divider 14, page 214, at paragraph 314, that is where Professor Norrie again addresses, if I might call it, the H&D paper.
Yeah.
And he identifies it as a lucid study in an excellent report. He points out again the difficulties of extrapolation. And then he says, as we're coming towards the end, he's happy to clarify his position that if the decision has been taken that to use the H&D model for this purpose, in brackets, extrapolating to risk at a very low exposure is appropriate, then what has been done by Professor Jones appears sensible and reasonable.
My lady's entirely right in going to that. Forgive me, I should have done that too. But what that does not say is that he accepts that the process of extrapolation is correct. What he says, and my lady's read it entirely correctly, if a decision is taken to use the H&D model, then what Professor Jones has done as a mechanical and mathematical exercise is sensible and reproducible. That is the process. But with the greatest respect, I'm not sure whether my lady's making a point that I need to use that sort of language for. Perhaps I'm overcautious. But he's not there saying it is appropriate to use the model. He's saying if you do use the model, he's done it mathematically correctly. But it does not for one moment go behind what he says in his evidence, which is don't do it. Don't use that model. Don't extrapolate in that way. He's very, very clear about that. Yes, perhaps the only further piece of material to address you, my lord and lady, on this aspect is what did Professor Jones think? What was Professor Jones's view? And I may, if I may, take you to two things. First is the judgment itself, paragraph 61. So this is Professor Jones, the defendant's toxicology expert.
Paragraph, sorry?
Paragraph 61 on page 126, behind tab 11 of core bundle.
Mm-hmm.
126. This the reference perhaps in the middle of paragraph 61, bearing in mind all of the uncertainties. This is the judge reciting his understanding of Professor Jones's evidence for the defendant, bearing in mind all the uncertainties in Hodgson and Darnton. It's necessary to look at other papers to try to put all comparisons, to assist with how one might treat very large uncertainties. He goes on to say Professor Jones had reassured from H&D that the sketchy attempt at model validation was supported. But in his report he was not purporting to provide an accurate figure because he did not have all the information needed for that to happen. He considered it a credible picture. So Professor Jones accepts the breadth and the inevitable inaccuracy in an extrapolation exercise, albeit not in the same trenchant terms that Professor Norrie gave. But we observe, as we have done throughout other parts of our skeleton, that Professor Jones is not a statistician. And if I may find, I believe it's in our skeleton already, so perhaps if I can refer to it and find it in due course rather than on my feet now to detain the court any longer than necessary. But Professor Jones accepted that matters of extrapolation would be matters for a statistician, which is what Professor Norrie is. My lords, I think apart from commending to you our skeleton running around to paragraphs 30-ish to 38, I'm not sure there's much more to add to developing ground one. We say the judge fundamentally got that part of the evidence wrong. we say that the only conclusion the judge could correctly have drawn was that extrapolating in this way from Hodgson and Darnton was unsafe and shouldn't be done. And if that's right, because that extrapolation is a fundamental part of method 2 that the defendant was advancing, the judge should have rejected method 2. The judge was presented with a binary choice between method 2 and method 1. And therefore, the judge should, had he not misdirected himself about the evidence he heard, have concluded that method 1 should be applied with the consequences I've already elaborated to the court. I'm not sure I can assist further on that point. My lords, in those circumstances, I'm going to do what I indicated at the outset. Those are the claimant's, appellant's submissions in respect of grounds 5 and 1, and my own perhaps slightly sketchy outline of the entirety of the case for you. I'm going, if I may, to invite Mr. Swoboda to deal with grounds 2 to 4.
Yes, thank you very much. Mr. Swoboda, we're going to ground 2.
Yes, my lord. My lord, my lady, ground 2 deals with the counterfactual risk. So whereas ground 1 dealt with the risk from the tortious exposure, looking at it through the lens of method 2, ground 2 looks at the counterfactual risk. What was Elaine's risk but for the tortious exposure according to method 2? In the defendant's case at trial was that Elaine's but for the tortious exposure risk of mesothelioma was a 0.5 in 1,000 lifetime risk. And to allow comparison to Hodgson and Darnton, that was put into the following figure, 50 in 100,000, so scaling up effectively from 0.5 in 1,000 to 50 in 100,000. And my lord, my lady, I don't think I need to take you to the point where in the defendant's skeleton before evidence where it's clear that this is their case, but for your note, for your reference, it's at paragraph 34, subsection 3 in the supplementary bundle at 57.
Well, I'm old-fashioned. I'd like to go everything by reference to the judgment.
Yes.
And isn't that recorded at paragraph 63 of the judgment by reference to the evidence of Professor Jones?
Indeed.
0.5 in 1,000.
Yes, yes, that's right. And indeed in 63, as I'll come on to submit in due course, the Professor Jones, that was his reflective of his written evidence, which was the basis of the defendant's case.
Yeah.
He changed his written evidence during the course of his oral evidence.
Yep.
To explain, my lords and my lady, where that figure comes from, it's helpful, I think, to look at the joint statement provided by Professor Norrie and Professor Jones, which can be found, the relevant sections can be found at page 219 of the supplementary bundle. And it's the sections of 4.4 to 4.9, and this is Professor Jones summarising the Petto, Rake et al. Study from 2009. He summarises it at 4.5, and then at 4.7, he talks about the lifetime risk for unexplained mesotheliomas in the order of 1 in 1,000 among Britons of both sexes born in the 1940s. And then at 4.8, he infers from what the section of text which he has set out at 4.7 that there are 3 contributors to that 1 in 1,000 risk. There is the risk of spontaneous, which is to say unrelated to asbestos, risk of mesothelioma. There is the risk arising from environmental exposure to asbestos, which is to say the inhalation simply by virtue of being born in this country, and the risk from unrecognised occupational exposure. And that's because, particularly for women, their work may have brought them close to exposure to asbestos, but they were unaware of it. What he says at 4.9 is that there's no clear way of dividing between the 3 sources. But what he does, and this you can see at the bottom of 4.9 and over the page on to page 222 of the bundle, he says, for comparison with risks estimated from occupational exposure, Professor Jones adopts a figure of 50% for the combination of genuinely spontaneous and ambient exposure in order to make a comparison. So he's getting rid of the unrecognised occupational exposure and just focusing on the spontaneous, not related to asbestos, and environmental exposure to try and find out what a background risk is for a woman, for a person born in the 1940s. And that is what he and the defendant assumes is the counterfactual risk in Elaine's case. The claimant's response at trial and now is that Professor Jones, and I do say this, his guess of 50% of 1 in 1,000 cannot safely be relied upon, and the adoption of that figure involves an improper use of statistics. The second of those arguments is dealt with in the first limb of ground 3. So I'll pause that, park that, until we reached ground 3. The issue crystallised before the judge was effectively, therefore, whether the 0.5 in 1,000 derived from Professor Jones's evidence and the Petter and Rake 2009 study could be safely relied upon as Elaine's counterfactual risk. That was the issue. And my Lord Coulson has identified that the learned judge below dealt with the issue of causation in terms of methodology at paragraphs 108 to 111 of the judgment. And at no point does he address that issue. What he does do, if one turns to paragraph 111 of the judgment below, which is at page 143 of the core bundle, is to say this. Where I do part company with Professor Norrie is the suggestion in his report when considering PNR that as EJ Elaine contracted pleural mesothelioma, she had had occupational exposure at defendants, that she would have been more likely to be in that 1/3 of cohort of cases in women recognised occupational exposure. That was a rather simplistic approach, born, I expect, unfamiliarity with this area of industrial disease by the role he undertook in this case. On the other hand, Professor Jones in his evidence demonstrated fairly compellingly why the level of Elaine's exposure was such that she would be more likely to be within one of the other of the remaining groups. And he here groups together ambient and unrecognised occupational exposure or idiopathic. His observations must now be seen in the context of my findings that Mr. Steer's calculations are to be preferred. This leads to a 0.1 or less increase in risk of developing mesothelioma. He doesn't anywhere self-evidently consider the actual issue, which was whether there was an evidential basis for a finding that 0.5 in 1,000 is Elaine's counterfactual risk of developing mesothelioma. He demonstrably misunderstood the issue and demonstrably misunderstood the evidence, not least because if one looks at the...
Well, hang on. You attack the finding of 0.5 in 1,000.
Yes.
But he doesn't make that finding.
No.
So I'm not quite sure on an appeal where this goes.
Well, he has to have adopted that finding, so he hasn't explicitly made it, but he has to have made it to reach the figure of 0.1.
Because that was Professor Jones's figure.
That's the only way you get to that figure.
Yeah, so that's Professor Jones's figure.
Yes.
And he says at 112, I found Professor Jones's insightful observations and opinions on the issues of lifetime risk, his work models and his conclusions highly persuasive.
Yes.
So he's adopting Professor Jones's evidence.
Yes, but as I said before, my lord, the key, this is a key issue. Professor Jones did not maintain 0.5 in his oral evidence. He moved very significantly away from that.
Right, okay, so that then is the point of this attack. It's to say, well, actually, by the end, that wasn't Professor Jones's case, and therefore the 0.1% wasn't correct.
Yes.
Okay.
That's exactly the issue.
It's not a question of him misunderstanding the evidence, which is what you said a moment ago. It's a question of him not noting the changes that Professor Jones made, presumably in cross-examination.
Yes, I can see how that could be interpreted that way, my lord. But the only point I suppose I would respond to that is that if he had accepted the 0.5 in 1,000 and understood that as to be the issue in the case, one would have expected him to record it somewhere in his judgment, which he hasn't.
Well, I don't think this appeal is going to be allowed on a question of reasons. We now understand, or I now understand, where the 0.5 comes.
Yes.
And why you say he shouldn't have found that, because you say Professor Jones on the oral evidence resiled from that.
Indeed.
So we need to compare that with the oral evidence, don't we?
Yes, we do, my lord. And if I may turn to that point now.
Yeah.
Can I, to put this in context, because it is necessary first to look at the actual paper to see the section of the report which Professor Jones relied on before moving to his oral evidence. My lord, if you'd prefer, I can go straight to Professor Jones's evidence, but I'm in your hands.
Well, if you want to show us the section of the report, because it's only by looking at that we can see the change that Professor Jones made, then
yes,
so be it.
Okay, well, I'll start with Professor Jones's evidence in that case. You have already, where he stood from the written evidence, 4.9 in the joint statement, which we've looked at already, is where he comes up with the figure of 50%, 1 in 1,000. But if we turn to the section that the part of the judgment that we were looking at, or that my lord, you directed me to earlier, paragraph 63, which is at page 126.
I'm so sorry, my apologies, I was looking at something. If you just give me that reference again.
Yes, of course, my lady. Paragraph 63
of
the core bundle at page 126. Right. Professor, what the learned judge below records is that, as my lord has identified, he explained how he reached a figure of 0.5 in 1,000, and he said a qualified guess at apportionment would be that it had to be less than 1 in 1,000, because there has to be some contribution from unrecognised occupational exposure. Having thought that 0.5 was a little too high and taking into account of spontaneous cases, the figure would be somewhere in the region of 0.1 to 0.5, depending on the magnitude of environmental risk. So that the learned judge below acknowledges the change in evidence because he records it in the final sentence of paragraph 63. If one goes then to the supplementary bundle, we can see the section that the learned judge based his finding on, and that's at page 306 of the supplementary bundle.
Yeah.
And it's by the letters A and B. He says, well, we know it's got to be less than 1 in 1,000. There's got to be some contribution to that from unrecognised occupational exposure, which is not something, says inaudible, to be considered on his basis and his attribution. I mean, having thought about it quite a bit during trial, we know it's a change because he's thinking about it during trial. I would probably now say that 0.5 is too high. But that may be taking account of inaudible figure for inaudible spontaneous. Probably it's going to be somewhere in the region of 0.1 to 0.5, so somewhere in that region. I think 0.5 probably is rather too high, although of course it depends on inaudible risk. Yes, somewhere in the region of 0.1 to 0.5 would be the range. So we can see this is the basis of the learned judge's findings. Mm-hmm. And if we turn, my lord, to page 294, this is my cross-examination of Professor Jones, and it's by the letters D to E.
What was that we were just looking at? Sorry, to be slow. The 306.
That was re-examination.
That was re-examination?
Yes.
Okay. Yeah.
That wasn't me probing him. That was offering it up himself, effectively, saying, yeah, I've thought about it. It's
but
not...
It was re-examination. It arose from your cross-examination.
Exactly, yeah.
Yeah, and so page
294 of the supplementary bundle.
Yeah.
By letters D running down to E. He says, to use your words, there's no... I asked the question, rather. So to use your words, because there is no clear way of dividing the risk between the three sources, it is impossible to make an apportionment of the background incidence rate in the Peto paper without ultimately getting, and he then says, I think perhaps a qualified guess, or trying to reason out what would be a reasonable range. So this is where the judge, where the language comes of it being a guess, a qualified guess. It's qualified by reference to the fact that he's deriving it from the Peto and Rake paper, which is why I wanted to go back to look at the paper to see what's actually said in that paper. And my lords, my lady, the three sources that he's identified, which go in to the 1 in 1,000 figure, unrecognised exposure. We don't know how much that is. So that has to be taken out from the 1 in 1,000. Then we have the two other parts which are left, which is environmental exposure and the spontaneous risk of mesothelioma. As to the spontaneous risk of mesothelioma, if we turn back a couple of pages to 292, at the bottom of the page, between F and G, I put a question to him referring to the Hildedal paper, which is concerns the risk of spontaneous mesothelioma not related to asbestos. And he says, over the page at 293, there's a quote from that paper, and the bottom final sentence of that quote says, well, what the true figure is can only be guessed, and that's referring to spontaneous mesothelioma, not relating to asbestos. Would you agree with that statement, I ask? And he says, I agree that the true figure is a very nebulous thing.
Yep.
And then over the page to 295, sorry to take you around different pages, all focusing on this question of the 0.5 in 1,000 as being Elaine's idiopathic risk. By A and B, it's broken up, but I asked the question, but there is, because you cannot provide any paper or scientific literature to support your 50% figure. And he says, no, other than what we can glean from Peto, I'm trying to think about it. So we know his source for that figure is just Peto, the Peto and Rake study. Can I, at this stage then, my Lord, take us back to the Peto and Rake study? And there are, it's a slightly unusual feature, but that study is reported in two different publications. One, it's published by the Health and Safety Executive, and it's also published in the British Journal of Cancer. And the two papers, the data is obviously exactly the same. The two papers are not identical, and it's worth just highlighting that. So if one looks at 341, this is the British Journal of Cancer.
Yeah.
And it's the bottom paragraph, and then 3 lines up, there's a sentence beginning, the annual number of unexplained mesothelioma cases. The annual number of unexplained mesothelioma.
Sorry, it's the right-hand column.
Yes, my Lord.
Last, which did you say?
It's towards the bottom of the page. There's a final paragraph, and then
The
3
final
lines.
paragraph that starts the cumulative female,
Yes, indeed. my
and
Lord.
then
3 lines up.
three lines up.
The sentence.
Oh, sorry, 3 lines up. The annual number. Yep.
Yes.
Yep.
And this is where he gets the annual number of unexplained mesothelioma cases is thus similar in men and women and corresponds to a lifetime risk of the order of 1 per 1,000 among Britons of both sexes born in the 1940s. So that's where that figure of 1 in 1,000 comes from. Mm-hmm. That's consistent again across both of the publications. And it goes on to state the cumulative female mesothelioma death rate by age 70 is now more than 3 times higher in the UK than in the US, if this is different due to differences in asbestos exposure. More than 2/3 of mesotheliomas in British women born since the 1930s are caused by asbestos, far more than the 38% that were attributed to identified exposures in our study. A similar conclusion is suggested by the 3-fold increase in the death rate in British women between 1975 and 1979 and 2000 and 2004. And then there comes this statement. This would imply that at least 30% of the order of 100 per year, 100 cases per year, are caused either by environmental asbestos exposure or by occasional and ambient exposure in occupational settings that we have classified as low risk. So the evidence of Professor Norrie at trial was that he couldn't understand how that statement was made from what came from the study. But in any event, taking it at face value as a mathematical proposition, as I understand it, what it's saying is this would imply that at least 30%, so there's 30%, no upper boundary, so between 30% and 100% are caused either by environmental asbestos exposure or occasional or ambient exposure in occupational settings which we've classified as low risk. If we look then over...
What does, this is very simplistic. Does that mean that up to 70% are idiopathic?
No, and you'll see there's... if we go to the health and safety publication, you can see that it can't mean that. So it's at page 345.
What else could the rest be?
No, so it's not, it's at least 30%, so it's only 30% that's left. The rest, at least 30% of female cases are caused by either environmental exposure or occasional or ambient exposure in occupational settings classified as low risk. So they're saying, as a minimum, not as a maximum, between 30 and 100% are due to asbestos in one form or another.
Right.
And if we look back...
So, but if...
Sorry.
That at least 30%.
Yeah.
Whatever that number is.
Yeah.
The remaining number up to 100 would be idiopathic.
No, it's the number... Well, I suppose it depends on how you look at it mathematically. But if they're saying 30 to 100% are due to asbestos, then 0 to 30 could be idiopathic. But their words are at least 30%. They're not saying it starts at 30%.
I see.
And sorry, I think, my lord, the point is answered better actually by looking at the HSE paper, which is at page 345, relevant section.
Sorry, 345.
345. And so the top paragraph, the final sentence of the top paragraph on 345 begins the same. So the annual number of unexplained mesotheliomas is thus similar in men and women and corresponds to a lifetime risk of the order of 1 per 1,000 among Britons of both sexes born in the 1940s. Exactly the same as what's said in the British Journal of Cancer publication. And then they go on to explain, as they had done, the difference between UK and US rates and the increase in mesothelioma rates, which they corresponds broadly with the use of asbestos in this country. And then there is a sentence about, after the numbers, after the year 2009, which begins these observations. And what he said is these observations suggest that at most, a third of all mesotheliomas currently occurring in British women are genuinely spontaneous, which is to say unrelated to asbestos exposure, far lower than the 62% that are unexplained in our study. So here, if I were to put that in other language, they are saying at most a third. So between 0% and 33% are spontaneous. And we've already got the evidence from Professor Jones that what the true spontaneous figure is a very nebulous thing. And there's real doubt whether there's any mesothelioma, plural mesothelioma, I should say, which is unrelated to asbestos, because everyone in this country has at some point been or is exposed to asbestos, just by virtue of living in this country. But the point, my Lord Zachary, does that, I hope that's the...
Well, I understand what that says.
Yes.
It seems to me to be different to what was said.
It is different.
Right.
It is different. It's definitely different.
Yeah.
And that's part of the confusion. It's different because there are two things which the authors say. One is that the environmental and unsuspected asbestos exposure, so asbestos related, is between at least 30%, but no upper limit, so up to 100%. Asbestos could be responsible for 100% of all of the mesotheliomas. And then they put it in a different way when they refer to spontaneous, because they say it's at most 30%, which is the same as saying it could be 0%. We don't know. So it doesn't help in any way, shape or form with the 0.5 in 1,000 that is the figure which Professor Jones put forward. And
Put forward in his report.
And in cross-examination, he confirmed that the only place
Yes.
he could reference...
And in
that,
re-examination, he qualified the figure and said
He did.
0.1 to 0.5.
He did, indeed. And just so that it's absolutely clear on that point, what he also said in respect of the Hodgson and Darnton study, which my learned friend, my learned leader, has taken you to, is that he couldn't put a central value on that. And I wonder now, I think now probably is a good time, just give the time, to deal with the point that, does this make a material difference to the outcome in the case?
We're on ground 2.
Yes.
The ground being that the judge misunderstood
Yes.
the case.
Yes.
Although you've accepted that there's no finding in relation to 0.5 in 1,000 anyway, so we're having to extrapolate from other findings that the judge did make that this is of any relevance.
Well, it must be of relevance because we know that he's adopted method 2.
Well,
And that's the only way to come up with the figure that he has come up with for an increase in risk.
well, yeah, there are a number of stages to that which we'll need to look at. But on the basis that the 0.1 to 0.5
Yes.
is the final point,
Yes.
were there then submissions as to what difference that made to the non-occupational exposure part of the calculation?
So if I turn back to then the written evidence that after the trial, so the skeleton.
Yeah, I mean, the judge rightly noted that change
Yep.
at 63.
Yes.
And so the obvious next question is, so what was it said, what difference was it said that made?
Yes. So to jump ahead, and I'll come back to answer my lord's question, it does make a difference because what we have is Professor Jones saying you can't use a central value for Hodgson and Darnton, and that has a particular context, and I'll come to that in a moment. And you also have a 0.1 to 0.5 for Peto and Rake. And that means that instead of having a single number, which is produced by method 1, you have a range. So if I can just put that all in context now.
What range were you saying to the judge?
So the way...
We have to be very careful
Yes.
to avoid island hopping through bits of the evidence.
Indeed, Mike.
It's really a question of what's in the judgment and what the material was before the judge. And in this instance, because there was a change in what was the evidence during the trial
Yes.
from what it had been before,
Yes.
then that would have been covered in submissions.
It was.
What I'm really asking is, where do I find
Yes.
this point in the submissions, and what was the claimant's case as to the difference that this made?
Yes, so that's at paragraph 34 of the submissions the closing submissions after trial, which is at page 72 in the supplementary bundle. Under the heading there is no practical way to adopt method 2. Those submissions relate to the Hodgson and Darnton side of the equation, but obviously there's
We're not talking about that. We're
No.
talking about the non-occupational risk. That's what ground 2 is concerned with.
Yes,
The 0.5 in 1,000.
yes,
And you've correctly pointed out that in re-examination, Professor Jones said, well, it could be 0.1 to 0.5.
Yes.
So the question again is, what difference does that make? And what difference was the judge asked to consider?
Yes. Can I deal with those two?
0.1% is the product
Yes.
of, amongst other things, the 0.5 in 1,000 you said.
Yes. Yes.
So what difference did it make to the 0.1%?
The reason that I'm not giving you a direct answer is because it depends on what figure that you use for Hodgson and Darnton. And because what Mr. Jones, because it's if you're using method 2, you have to choose a figure from Hodgson and Darnton and a figure from Peto and Rake. And whichever figure you use on both sides of the equation will give you a different answer. So to
Last go. When the witness modified his evidence to 0.1 to 0.5,
yes,
that had an effect on his calculation
yes,
of 0.1%. What is the figure that produced?
it will cut
On his calculation.
On his-
So he chose figures
Yes.
from both of those two papers
yes.
to get to his 0.1%. So what's the effect on his figure?
It's up to 2.2%. That is the effect.
Where do I find that in the submissions made to the judge?
Perhaps I could assist my friend here. If one looks at paragraph 59 of the judgment, you will see the range of risks on that table in paragraph 59. And if you change the denominator, which is Peto, let's say from 0.5 to 0.25, midway in the range, all you do is multiply by 2. So the best estimate you can see in that table will go from 0.022 to 0.044. So that's the way you'd use the denominator.
So, sorry, which paragraph are you looking at?
Paragraph 59 of the judgment.
That's relating to Hodgson and Rake. Hodgson and Darnton. No, that
Peto and Rake, correct.
Hodgson and Darnton. That's the Hodgson and Darnton table. That's
Yes,
not
but-
Peto and Rake.
But the denominator works by dividing the Hodgson and
It does. It does.
So if you double the underlying rate, all you do is you multiply 0.022 by 2, which is 0.044.
So, just to sorry, what my learned friend has taken you to is a helpful table from Hodgson and
I
Darnton.
just want to know your case.
Yes.
I don't think I'm capable of putting it in any other way. We looked at a change in figures,
Yes.
which you say had an effect on the 0.5 in 1,000, because he said
Yes,
it could be 0.1 to 0.5. His figure was part of the input that got to the 0.1% material increase.
Yes.
And what I want to know, last chance, is what the judge was told what difference that made to the 0.1% figure.
So, my lord, I can tell you this. At the trial below, I said that, as I've recorded in the written submissions, the judge could not adopt method 2 because it wasn't practicable. Because
Exactly.
yes,
Exactly. And that may be the difficulty with ground 2, because the judge wasn't asked to reflect that in any particular figure. He was told, don't use method 2.
yes, which I say is entirely right because there was.
That's ground 3, which we'll come on to. But
No, it's also method 2. It's also ground 2, my lord.
Well, at the moment, my difficulty with method 2 is it makes a very specific criticism of the judge, which then didn't pan out in terms of the final submissions.
Yes, I can see that, my lord. So when I said there was no practical way for method 2 to be adopted, it's because there was a range of figures. So one could not adopt 0.5 because there was nobody putting evidence forward on that basis. So you couldn't say it was 0.5. You could only say it was 0.1 to 0.5 on Professor Jones's evidence. But the point, and I'm sorry to labour the point, but could I, my lord, if you will indulge me, just ask you to look at
Sure.
the page 100 and I'm sorry, my lord. I just wanted to make sure I get this page reference right. Thank you. 284 of the supplementary bundle.
Yeah. $184.
284.
Oh, sorry. Yeah.
What is said?
Hang on, whose evidence are we looking at?
This is Professor Jones. Yes,
And this is you cross-examining.
it is.
Yep.
No, just to be clear, it's evidence in chief.
Oh, it's
Examination in chief. This is what he himself was saying.
Yeah.
So at the bottom of the page, he says, it's being asked of him, can you, this is by F, is that you seem to explain it as a cross-stitch or a freestanding second analysis, and this is by reference to what he's done with Hodgson and Darnton, and he answers, yes, I think in the absence of anything else, it is trying to put all the comparisons that one can make before the court. And then it is for the court to make sense of that, including how to treat the very large incentive, I think it should be uncertainty, in Hodgson and Darnton, which is something you do not necessarily always have cause to look at. So there's a temptation to produce a central value, but you simply cannot. This is his evidence about not being able to use a central value for Hodgson and Darnton. And if one turns back to the table that my learned friend took you to in the core bundle, under paragraph 59
Of the judgment.
Of the judgment, you have here the tortious risk from Hodgson and Darnton using Mr. Steer's figures on the bottom line, and then you have from Hodgson and Darnton what they say is a best estimate, a lowest arguable, and a highest arguable. And if you put that in the context of you can't use the central value, what he is saying, what I understood him to be saying was you can't choose which of those figures to adopt. And the reason, my lord, that I'm labouring that point is because which figure you use for Hodgson and Darnton depends on the figure that you get out when you do method 2. Because there's two parts to the equation, the tortious risk, which is Hodgson and Darnton's figures, and the counterfactual risk, which is Peto and Rake, or the figure that Professor Jones took out from Peto and Rake. And so what you have, to give it an exact calculation on Professor Jones's evidence, you have 0.0006 to 0.22 being the numerator to use in the calculation, and between 10 and 50 being the denominator, that's the Peto and Rake figure. So between 0.1 and 0.5. And there, if you use that range at the bottom of the range, it is clearly de minimis. But at some point, it changes into a material risk. And at the top of the range, you get 2.2%. So applying method 2 on the changed evidence of Professor Jones does not provide the court with a practical way to resolve Elaine's case, because it doesn't tell you whether it's a material risk or not a material risk, because at the top of the range it is a material risk, and at the bottom of the range it isn't. And Professor Jones is explicit in his evidence that you can't, A, use a central valuation for Hodgson and Darnton, and B, he changes his evidence to say that it's between 10 and between 0.1 and 0.5 for Peto and Rake. And that was a point, that was the very point I was making when I submitted to the judge below, as I've taken you to in the written submissions. There is no practical way of adopting method 2. My Lord, I can see that we are nearly at 1 o'clock. I wonder if now is a convenient moment.
So that's it on ground 2.
No, my lords, no. I'm sorry, it's not. The reason that I would like to address you further, if you may, if you will allow me, is because the respondent argues that they can rely on Dr. Moore-Gillen's evidence in support of the counterfactual risk, that 0.5 in 1,000 figure, and that does not bear a scrutiny of the evidence. And I'd like the opportunity to demonstrate that point.
Yes, all right. Well, you can do that, but bear in mind, all of this is an attack on a finding that the judge didn't expressly make.
No, but that one which was implicit.
He didn't expressly make. And, I mean, I have all the points about it not being, that he didn't take account of this, that, and the other. But it's a slightly odd position to be in. I mean, usually grounds of appeal identify the paragraph of the judgment that's under attack. This doesn't. I wondered about that, and I now understand why, because it's not actually a paragraph of the judgment. It's ultimately, you say, it comes out in the final figure.
Yes, he hasn't. My attack is that he hasn't considered the issue at all.
Say again?
My attack is that he hasn't considered the issue at all, because if he had, he couldn't have reached that 0.1 figure.
I understand that point on matter of principle. All right, well, we'll come back at 2 o'clock.
Lord, just before we rise, could I just mention, Lord Justice Zacaroli was asking about 5 million years, and there is a definition in the papers, or a helpful explanation by Dr. Moore-Gillen at Supplementary Bundle 242, that it might be worth having a look at it.
242.
If I may also have the liberty of detaining you for 30 seconds before lunch. At the end of my submissions, my Lady Justice Nicola Davies asked me, I was trying to find for you the reference where the defendant's expert, Professor Jones, defers to statisticians, and that is in the supplemental bundle, tab 21, page 305, at the very top of the page, letter A, and it goes to the point on extrapolation. He is asked, what we're talking about here is drawing statistical reliability for extrapolation. That is reflecting the fact it's a model, it's best reflected on by a statistician, and he says yes. So my submission reinforces the judge could not and should not have gone against Professor Norrie. Apologies.
That's all right. Anything else?
Nope.
2 o'clock. Thank you very much.